Question 370. An unlawful detainer action can be commenced by a landlord against a tenant when a. The tenant fails to leave upon the expiration of his lease, b. The property is sold, c. There is a month-to-month lease, and the tenant does not move out after a 30-day, 60-day or 90-day notice to quit, d. All of the above. Correct answer is D. All of the above. Here's why an unlawful detainer action, which is a legal process to evict a tenant, can be commenced in each of these situations in California. A. The tenant fails to leave upon the expiration of his lease. When a lease with a specific end date expires and the tenant remains in possession of the property without the landlord's consent, they become a holdover tenant. The landlord can then initiate an unlawful detainer action to regain possession. B. The property is sold. While a sale itself doesn't automatically terminate a lease, the new owner may have grounds to terminate the tenancy depending on the terms of the lease and California law. If the lease allows for termination upon sale, or if it's a month-to-month tenancy and proper notice is given by the new owner, and the tenant fails to vacate after receiving a valid notice to quit, an unlawful detainer action can be filed. C. There is a month-to-month lease, and the tenant does not move out after a 30-day, 60-day or 90-day notice to quit. In California, a landlord can terminate a month-to-month tenancy by serving the tenant with a proper written notice to quit. The length of the notice required depends on how long the tenant has resided at the property. 30-day notice if the tenant has lived there for less than 1 year. 60-day notice if the tenant has lived there for 1 year or more. 90-day notice in some specific situations, such as when the property is being withdrawn from the rental market under the Ellis Act. If the tenant fails to vacate after the expiration of a valid notice to quit, the landlord can proceed with an unlawful detainer action.